This is Michael Popok, Legal AF, with breaking news. Well, the Fifth Circuit Court of Appeals in an en banc 13-3 decision has done it again. They've overturned a major principle of public safety to protect innocent people from shooting, violence, and death by overturning the alcohol, tobacco, and firearms banning of bump stocks, converting semi-automatic weapons into effectively automatic weapons. It was a regulation that was passed actually in the Trump administration in the wake of the carnage and death toll and tragedy in Las Vegas on October 1st of 2017, when 60 people attending a concert were massacred by one lone gunman sitting in a room in the Mandalay Bay Hotel, shooting a converted semi-automatic weapon using a bump stock, which I'll explain later, and creating a killing machine firing 1,000 rounds of ammunition within a less than 10 or 15-minute period of time, killing 60 of our citizens and wounding dozens others. The right thing to do from a public policy standpoint was to find an existing set of regulations consistent with the Second Amendment as interpreted by this right-wing Supreme Court, and ban killing machines, weapons of mass destruction that have nothing to do with hunting, the right to bear arms, or a well-regulated militia. And that is what the Alcohol, Tobacco, and Firearms through executive order did in finding that the bump stock attachment being sold at the time was converting this device into an illegal machine gun and therefore should be banned. That was done not by Congress, not by an act of Congress, but by the executive branch through one of its agencies, the Alcohol, Tobacco, and Firearms Bureau. And that is the major problem, apparently, that the Fifth Circuit had with the issue in ruling against the ban, finding it to be a violation of the Administrative Procedures Act and of a little-known and little-discussed doctrine called the Doctrine of Lenity, Lenity, which is a doctrine that dates back to the founding of our republic and applies when criminal law is being applied in a way that is not consistent or doesn't give fair warning to people that what they are doing is a crime. And therefore, Chief Justice Marshall, back in 1820, ruled that there is a tenderness about the law for the rights of individuals, to which I retort, where is the tenderness of the law for the rights of those not to be shot and killed as innocent civilians while they are attending a music concert in an outdoor field? Where is the tenderness of the law? The order that was written, the 65 or so page order in the case of Michael Cargill versus Merrick Garland, the Department of Justice and Alcohol, Tobacco, and Firearms Bureau, which was passed, which was ruled upon, and the final opinion issued by Judge Jennifer Walker Elrod, a W. Bush appointee to the Fifth Circuit. But the full en banc panel, all 16 members, participated in the ruling, and 13 of them thought that it is completely fine to have bump stocks converting semi-automatic weapons into killing machines to allow for the carnage that happened in Las Vegas and in other places. And they spent such an amount of exquisite time and terrible, ironic time writing about the intricacies of how a bump stock works and how a trigger fires and all the little minutia of the parts of a weapon, of a handgun, of a semi-automatic weapon, and rifle in this case. Such excruciating detail that could have only come from submissions by gun rights advocates in their briefing, like the NRA and others. I don't think a clerk of one of these Fifth Circuit judges went out and did their own research. I'm sure it was spoon-fed to them. The schematics, the diagrams. It was almost pornographic in the way that they described almost the beauty of a gun and how it operates, and the difference between a bump stock on a semi-automatic weapon and a machine gun. But what was completely missing except in one line in Judge Elrod's order for the full en banc panel. There was no reflection or no acknowledgement of the human suffering and carnage that happens on the other end of the gun barrel, with innocent victims being slaughtered every day in America. In an America that is awash with too many weapons, none of which were contemplated by our founding fathers. And so if we're going to use what they call strict construction and the rules of strict construction, which is what's going to happen when this eventually goes to the right wing of the Supreme Court, they're going to go back and say, well, if there were no limitations on similar things like bump stocks on semi-automatic weapons back in the 17 and 1800s, stop. That weaponry wasn't even contemplated by the founding fathers, that there could be such a thing. They resided in a time where you had to use a musket and gunpowder and little balls. There was no semi-automatic weapon. It was the opposite. It was the weaponry of the founding fathers was barely automatic. It took them minutes between firing a round to fire the next round, as compared to Las Vegas, where the shooter fired 1,000 rounds in a very brief period of time. So stop talking about what the founding fathers would have felt or thought about from their grave about how to legislate a bump stock. That is a fantasy world that the right wing resides in and the strict constructionist resides in, who want to defend the Second Amendment above all else, including the public health, safety, and welfare. And the way they did it in this particular decision, which is at odds with three other circuits in the United States federal system, the Sixth Circuit, the 10th Circuit, and the D.C. Circuit Court of Appeals have all ruled that the bump stock ban is appropriate exercise. They mainly got to that ruling, that proper ruling, to find this public policy to be properly implemented. Under another doctrine of interpretation, which we all call in the law the Chevron doctrine, comes from a line of cases that were brought by Chevron. And the Chevron doctrine basically says that the courts will give great deference to the administrative interpretation or the interpretation of administrative law and regulations by agencies that have been invested with that authority by Congress. So an agency gets a lot of a leeway and ties go to the runner, if you will, by an agency to interpret its own rules under the Chevron doctrine. Now, for some reason, the Biden administration, in filing its briefs to the Fifth Circuit, did not at all rely on Chevron, even though the Chevron doctrine had been successful and used by at least the Sixth and 10th Circuit, either because they don't believe it's really properly applicable, or they thought they had a great case on a statutory interpretation. Well, the Fifth Circuit saw that opening, that loophole, and drove a truck through it, and actually said that the main reason that they're not applying or interpreting the Chevron doctrine to the case because the Department of Justice didn't ask for it. But then went on to say even if they were asked to apply Chevron, they would have found it doesn't apply because we're in a criminal context, because the ban criminalized the ownership of bump stocks. And then they moved to the other sort of companion to Chevron, which is the law of lenity, Lenity, which is a law in criminal law that says people have to be on fair notice of what is or is not a crime, and they shouldn't be left to guess. And if there's an ambiguity in a criminal law, then you go back to the legislature, you go back to Congress, and only Congress can fix an ambiguity. So they found there was an ambiguity. They didn't like the way that the Fifth Circuit didn't like the way alcohol, tobacco, and firearms interpreted the definition of machine gun. They said that in the past you've said that machine gun is not the bump stock, a mechanical bump stock, and now you say it is. And we find that variation or variance to be troubling, and it should all go back to Congress. But while it goes back to Congress, a Congress now controlled by what we saw on January 6th, not 2 years ago, but just 2 days ago, a Congress that is completely now leaderless, no, more to the point, led by 5 or 6 MAGA right-wing, election-denying, women's rights denying members of Congress, which if you add up the total amount of their population that they represent, if you add up all of the 14 or so that were against McCarthy, it would be about 0.5% of the U.S. population. That's what they represent. And that 0.5% is what's controlling for the next 2 years American policy. And they will never, in their mind, regulate or abridge the Second Amendment in any way. And they're okay, by extension, with what happened in Las Vegas on 10/1/17. They're okay with school shootings. They're okay with our most vulnerable in our society, children, people enjoying themselves, unarmed civilians, to be slaughtered and killed as if they're on a battlefield. That is okay with the right-wing Republicans and the 14 staunch Republicans that fought against McCarthy's appointment. So there'll never be the reality of the Fifth Circuit, even though they'll bury their head in the sand and say things in their opinion like, our job as a court is not to define the nation's public policy. Isn't that easy for Judge Elrod to say, wearing her black robe, probably never having been on the other end of the barrel of a gun? This story is also personal to me. By complete coincidence, I was in Las Vegas the afternoon of the night of the shooting. I was not at the concert, but I was across the street at another casino hotel because I had a court appearance the next day in an unrelated case. And I had 2 colleagues with me. One of my colleagues was landing on the runway of the airport in Las Vegas at the moment of the shooting and texted us while we were waiting for her at the hotel for dinner, and texted us that she saw something strange. She saw people running she didn't say for their life, but now we know, running in the direction of the planes onto the runway. And we saw that, and we said, isn't that strange? Why would that be happening? What was she observing? And we sort of rubbed our eyes and said, that can't be true. And we never saw that colleague that night. We did see her a day later because within half an hour of receiving that text, my other colleague and I, on a report of an active shooter, which was false, but part of the hysteria of the moment of what was happening out at the concert field, were told by hotel security, along with everybody else in the restaurant we sat in, that there was an active shooter and that we had to get up quickly and run through the kitchen to safety. There was no real plan once we got out of the kitchen and into public view outside. But I can't express to you the sheer terror of being told, and I actually asked the question to the security guard when he said, everybody's got to get out of here right now and go through the kitchen to safety. And I looked him in the eye, and I don't know how I had the presence of mind, but I said to him, active shooter? And he said yes. And frankly, even though I had had a couple, that's all I needed to hear. I sobered up pretty quickly with my other colleague, and we ran to safety, made our way back into our rooms, locked our doors, and prayed for what was a developing story about 60 Americans dying. And I went to court on Monday morning, and the lawyers in court were all traumatized, all asked for continuances and extensions of their cases because of what had just rocked the Las Vegas community. And when I flew home early, because I was supposed to be there for the rest of the week, but when I flew home early on that Tuesday, actually people on my flight, including an older couple, had been hit with shrapnel from the firings, had already been tended to medically, were wrapped in bandages, and were back on my flight to bring that home even more. And my hands shook for most of that flight home. So this is personal to me because I could have been easily being in that time and place on the receiving end of a bump stock enhanced semi-automatic weapon firing at me mercilessly from a perch, from a vantage point, thousands of yards away at a hotel. So let me end it with the explanation of what is a bump stock, so that when you talk about this with your friends and family and others, you know what you're talking about. So a bump stock, in this case, is a mechanical device that is attached to a semi-automatic weapon. And when you lean into it, it goes underneath the weapon and attaches to the handle in the back. And when you lean into it with your body weight and you depress the trigger, it harnesses the recoil energy and allows the bullets to continue to fire. The trigger is actually firing in sequence over and over and over again, but you only have to pull the trigger once. So effectively, you've converted a semi-automatic weapon to an automatic weapon in the vernacular, because now you're able to fire 1,000 rounds in an incredibly short amount of time. That is the device that gun rights advocates tell people they have the right to have in their home for who knows what reason. So when people say to you, I have a Second Amendment right to protect myself, these right-wing extremists and gun rights activists who see no ability to regulate in this area think it's okay to have an automatic machine gun-like weapon firing rapidly for what? You're never going to go up against the U.S. military as a militia. You're never going to overthrow the country, although we saw an attempt on January 6th. So what is the purpose of it? And it's only because, in their mind, any regulation on the right to bear arms is intolerable. And that has led us now to what the Fifth Circuit has done. So the ramifications of it is we have the Fifth Circuit ruling that the bump stock ban is illegal and has to come off the books, while the three other circuits have ruled that it is fine and appropriate, public policy, properly passed, which means with a conflict of the circuits, it should go to the U.S. Supreme Court. And we know, if we know anything, this U.S. Supreme Court, controlled by the right-wing MAGA extremists that were appointed, who call themselves Republican conservative, but are nothing of the sort, believe that the Second Amendment trumps all other amendments, and there can be almost no regulation that they will find appropriate. So I hate to make predictions of this nature, but if the bump stock ban gets to the U.S. Supreme Court, don't be surprised if the right-wing majority upholds the ruling of the Fifth Circuit and finds that unless Congress tries to ban it, and even then it would violate the Second Amendment, they will throw out any regulation that restricts the ability to add a bump stock device or something similar to it to a semi-automatic weapon. This is Michael Popok, Legal AF, reporting.
Our blue wall stopped the red wave and election deniers got denied election. That's why we're celebrating with the new Democracy Prevails team. We've got lots of work to do, but we should all be proud that when democracy was tested, democracy prevailed. You've earned this. Don't wait. Get yours right now at store.MeidasTouch.com. That's store.MeidasTouch.com.